Hello and welcome to LiveLaw. This is your host Syed Amir Hussain, and in this video we will be talking about a really interesting topic, the IT Rules Amendment 2023. This video is in light of the verdict pronounced by the Bombay High Court on 26th of September striking down the 2023 amendment. Before talking about that judgment, let us first understand the IT Rules Amendment and the split verdict from the division bench. So, the Information Technology Amendment Rules of 2023 grant the Union Government the authority to remove any online content pertaining to its business that it deems to be false or misleading. Under these rules, social media platforms and intermediaries, along with digital news platforms and media publications, will be deprived of the protection of the safe harbor principle if they fail to comply with government orders. The use of vague and broad wording in respect of any business raises concerns over its chilling effect on the right to freedom of speech and expression. Now, what is this safe harbor provision? It has been given under Section 79 of the IT Act of 2000. It states, an intermediary shall not be liable for any third-party information, data, or communication link made available or hosted by them. As a result of these amendments, information about the Union government would essentially be fact-checked by the government itself through an FCU or a fact-check unit established by it. Not only does this violate the principles of natural justice, wherein one can't be the judge in their own cause, but also poses a huge threat to online free speech and the right to receive information online. The IT Amendment Rules of 2023 are a consequence of the Ministry of Electronics and Information Technology's continued efforts to impose obligations on online intermediaries and digital news and media platforms. In the name of increasing accountability, these rules were then challenged before the Bombay High Court in April of 2023 by political comedian Kunal Kamra, who said the impugned rules are manifestly arbitrary, as they entail the central government acting as a judge and prosecutor in its own cause, thus violating one of the most fundamental principles of natural justice. In this matter, the central government contended, through Solicitor General Mr. Tushar Mehta, appearing for the Union, that the FCU only flags fake news regarding government business to the intermediaries. The SG clarified that the impugned rules have been notified to manage government business as defined in the Transaction of Business Rules. SG argued that the impugned rules are the least restrictive measures adopted, drawing a comparison from the power of the government to issue directions to block content under Section 69A of the IT Act. The SG clarified that the FCU only cross-checks and informs the intermediaries of the false information from the official records. SG said, genuine information leads to an informed decision and misinformation leads to misled decisions. Audio-visuals made up of a bundle of facts shared through the internet have an actionable impact on the recipient of the information, which forms the basis of a citizen's decision. It was the Union's submission that the impugned rule neither prohibits nor places any embargo on the freedom of speech and expression of an individual, and there is no pre-publication seizure. Section 79, subsection 2C of the IT Act mandates the intermediary to have an inbuilt system to check for patently false or misinformation, knowingly and intentionally appearing on its platform. The impugned rule does not create any obligation on the intermediary to either take down flagged content or block the same, and the impugned rule merely provides for the identification of fake, false or misleading information by a FCU, where such information which is knowingly and intentionally shared via the intermediary. The only consequence is a wide dissemination of a public announcement that such information is either fake, false or misleading to enable the intermediary to employ due diligence. It was also stated that the object of amending the rule is to curb the deception of the masses by a supply of distorted and misleading information, the spread of which presents a clear and specific danger, squarely falling within the restrictions laid down under Article 19, Clause 2. When it comes to the petitioner's argument, appearing for Kamra, senior counsel Sirvai pointed out the lack of remedies available to users if their content is flagged by the FCU as fake, false or misleading, and argued the only recourse for users is a writ petition. Sirvai submitted instances where the Press Information Bureau has been called out for putting out incorrect information to imply the government may not always disseminate true and correct facts, how it throttles information that embarrasses the government. Giving an example of how this would play out, Sirvai said, WHO may say 50 lakh people died of COVID. India says only 5 lakh died. FCU says what WHO claims is false. See how the government will be shielded? Then, after months of deliberation, the Bombay High Court on 31st January 2024 delivered a split verdict on the pleas seeking to strike down Rules 3, Sub-Rule 1A and C of the IT Amendment Rules 2023, which empowers the central government to establish a fact-check unit to identify any fake, false or misleading information about its business on social media platforms. In this judgment, Justice Gautam Patel said he has ruled in favor of the petitioners, political satirist Kunal Kamra, Association of Indian Magazines, News Broadcasters of Digital Association and Editors Guild of India. At the same time, Justice Neela Gokhale had upheld the amendment. The matter was then placed before a third judge as per the Bombay High Court rules. Justice Gautam Patel in his judgment said, "What troubles me about the impugned 2023 amendment and for which I find no plausible defense is this. The 2023 amendment is not just too close to, but actually takes the form of censorship of user content. There is no material difference between this and the newsprint cases of the 1990s. I should not be misunderstood. This is not a comment on this or that dispensation or the present government. I am only considering the effect of the impugned amendment. The impugned amendment makes the government's chosen FCU the sole authority to decide what piece of user content relating to the undefined and unknowable business of the government is or is not fake, false or misleading. The lack of definition of these words, business of the government, fake, false and misleading, makes the amendment both vague and overbroad. How the FCU will go about its business is also unknown. We are simply asked to trust it. This is not a question of trust and especially not of distrust in any particular dispensation. It is simply a matter of setting the impugned rule against the settled law and seeing whether it passes established constitutional tests. The submission on Article 14 and the invalid classification is, in my view, correctly placed for these reasons and the ones set out at greater length in the preceding discussions. I would strike down the 2023 amendment to Rule 3, Sub-Rule 1B5 of the Information Technology Intermediary Guidelines and Digital Media Ethics Code, Rules 2021. I regret that I have been unable to persuade Justice Gokhale to my perspective, nor I to share hers. We have, with due respect to each other's views, agreed to disagree. On the other hand, Justice Neela Gokhale in her judgment concluded the impugned rule is not violative of Article 14 based on the FCU comprising of government officials, thereby making the government the final arbiter in its own cause. Secondly, alleging bias against the members of the SCU only for the reason of their being government appointees is unfair, and this by itself does not divest their character as independent persons. The rule, plainly read, targets misinformation, patently untrue information, which the user knows to be fake, false or misleading, and yet is shared with a malified intent. The qualification for offensive information is knowledge and intent. Political satire, political parody, political criticism, opinions, views, etc. do not form part of the offensive information. Content comprising of a critical opinion or a satire or parody, howsoever critical of the government or its business, if it exists and is not fake or known to be false or misleading, does not fall within the mischief sought to be corrected by the impugned rule. The impugned rule meets the test of proportionality. The right of citizens to participate in the representative and participative democracy of the country is meaningless unless they have access to authentic information and are not misled by misinformation, information which is patently untrue, fake, false or misleading, knowingly communicated with malicious intent. In these terms, the petitions are dismissed. Post this judgment, the matter was then presented before Justice Atul Chandurkar in February of 2024, and after various dates, he reserved the judgment on 8th of August 2024. While on March 21st, the Supreme Court stayed the union's notification of the fact-check unit under the Information Technology Intermediary Guidelines and Digital Media Ethics Code Amendment Rules 2023 or the IT Amendment Rules of 2023. The stay was to operate till the Bombay High Court finally decided the challenges to the IT Rules Amendment of 2023. A bench of Chief Justice D.Y. Chandrachud, Justice J.B. Pardiwala and Justice Manoj Misra held this while hearing the special leave petitions filed by Kunal Kamra, Editors Guild of India and Association of Indian Magazines challenging the refusal of the Bombay High Court to stay the implementation of the IT Rules of 2023. The tiebreaker judge then, on Friday, September 20th, struck down the 2023 amendments to the IT rules. I am of the opinion that the amendments are violative of Article 14 and Article 19 of the Constitution of India, he said while pronouncing his opinion on the issue after a division bench of Justices Gautam Patel and Dr. Neela Gokhale had delivered the split verdict. Justice Chandurkar also said the amendments are also violative of Article 21 and do not satisfy the test of proportionality. The tiebreaker judge has also held that the citizens only have the right to free speech and expression, but not a right to truth, and thus the state cannot claim to have a responsibility to ensure that citizens know only truth and not fake or false information. In his 99-page judgment, Justice Chandurkar criticized the central government for attempting to become an arbiter in its own case. The judge further noted that the FCUs will identify information which is fake or false with regard to the business of only the central government and not of the state governments. Moreover, the judge found that there were no guidelines to be followed by the FCUs to ascertain or declare certain pieces of information as fake or false news. The judge, while referring to the very aspect, held that the amendment would also infringe the right to equality of digital platforms, as the amendment would not apply to information put on digital media, but not when published in a newspaper. Then, after receiving the opinion of the tiebreaker judge, the Bombay High Court Division Bench on 26th September declared the amendment to the IT Rules 2021 unconstitutional and struck down the said amendment. The bench of Justices Ajay Gadkari and Dr. Neela Gokhale allowed the petitions. In view of the majority opinion, the Rule 3, Sub-Rule 1.5 is declared unconstitutional and is struck down. Petitions are accordingly allowed, the bench said. Now, you might remember that a division bench of Justices Gautam Patel and Dr. Neela Gokhale had delivered a split verdict in this matter in January. But since Justice Patel has now retired, the matter was placed before a division bench of Justices Gadkari and Gokhale, which pronounced the final verdict and struck down the amendments, with a majority view holding it unconstitutional. Now, after understanding the complete matter, do let us know what you think about it in the comments section below. Don't forget to subscribe or follow LiveLaw depending on the platform this content reaches you. Support us by sharing this video to inform more people about this matter, and I will see you soon in the next video. Till then, stay informed. Thank you.